Hello, Professor Bornstein and my legal pluralism class. How are you today? I'm going to discuss Antoine v. Washington, 420 U.S. 194 from 1975. So let me give you a summary of the case before it went to SCOTUS. Frank Antoine and another Colville tribal member went deer hunted on ceded lands, lands that were originally belonging to the tribe. There was a treaty with the federal government to give the lands back to the federal government. However, they were charged by the state of Washington for violating state hunting regulations. They didn't have permits, and it was closed season. The tribal members argued that the agreement from 1891 gave them a treaty-based right to hunt on the ceded land without any state interference. Washington state courts upheld the convictions, reasoning that the 1981 agreement was not a treaty since it was ratified only by Congress and not signed by the president. It wasn't a law, it was a treaty, and thus didn't protect hunting rights. The central question was, did the 1891 agreement, even though it was a formal treaty, still have the force of federal law protecting hunting rights from state regulation? The Colville Indian tribe challenged the state of Washington's attempt to regulate their hunting and fishing rights. The tribe had ceded land to the government by an agreement made in 1891. That same agreement reserved certain rights for the tribe, including hunting and fishing rights. The Supreme Court held that the agreement did carry the force of law, meaning Washington state could not regulate tribal hunting and fishing rights reserved under the 1891 agreement, even on ceded lands. Arguments of the plaintiff, the tribal members, they claim that the Colville tribe was guaranteed their right to hunt and fish without regulation in that 1891 agreement. What were their standing requirements? The tribe argued they suffered concrete injury because Washington's hunting and fishing laws criminalized their traditional practices. And the cause for this injury was directly by Washington state's enforcement of its state laws on tribal ceded land. And what's their redress? What would make them whole? If the court invalidated the state's enforcement, their rights would be restored and the injury would be redressed. Arguments of the defendant, Washington state, they argued that the 1891 agreement had no binding legal effect because it was approved only by a joint resolution of Congress, not a formal law. They said the agreement was a contract, not a treaty, and therefore it could not bind the state of Washington, which was not a party to it. The federal government had no authority to surrender or limit Washington's police powers over hunting and fishing. And in the phrase quoted from Article 6 of the 1891 bill, the phrase, in common with all other persons, only guaranteed equal access to hunting. What were the laws involved in this case? One would be the 1891 agreement with the Colville tribe, which reserved hunting and fishing rights to the tribe. And the ratifying legislation must be construed in the light of the long-standing canon of construction that the wording of treaties and statutes ratify agreements with the Indians is not to be construed to their prejudice. There's the federal Indian law principle. Congress has plenary, and that means complete authority over Indian affairs, and its actions, whether by statute or resolution, are legally binding. Washington's Constitution states, and this is very interesting, that the people inhabiting said proposed state do agree and declare that they forever disclaim all right and title to all lands lying within said limits owned or held by any Indian or Indian tribes. So Washington became a member of the United States after 1891, and this state was required within their constitution by the federal government's Enabling Act for Washington statehood. They are considered an irrevocable ordinance, cannot be taken out. Key earlier cases, I'm going to start with the one that's actually mentioned within the Supreme Court's decision. It's called United States v. Pelican. It's from 1914. That lands within the public domain, which are not subject to the exclusive jurisdiction of the federal government, are subject to the jurisdiction of the state. There was a defendant who committed murder, allegedly. I don't know the outcome of the case, but he did not want to be tried in the state courts. He wanted to be tried in the federal court because federal courts were seen as more consistent with treaty protection. So this person did not want to be tried in state court where they felt they might be more prejudicial. They wanted to be tried in federal court, and since the murder occurred on federal land, that's what they wanted to do. Took it all the way up to the Supreme Court, and the Supreme Court said, yeah, you're right. Another earlier case is Choate v. Trapp was established when Congress grants property rights like tax exemption or allotment patents. They're legally binding, and that states cannot ignore and Congress cannot later revoke without due process. Worcester v. Georgia in 1832, much earlier, established that states have no authority over tribal lands. The Supreme Court, in an opinion by Justice John Marshall, held that Indian nations are distinct political communities with their own sovereign, and that state laws have no force within tribal land. Only the federal government, not individual states, has authority to deal with tribes. The principle here is that of tribal sovereignty. 1908, Winters v. United States is an important one. It affirmed that treaties and agreements with tribes carry enforceable legal rights, especially in natural resources, known as the Winters Doctrine. And this case established that tribes have reserved water rights superior to later state water claims, ensuring that they have the resources needed to make lands available and productive. And that's very important now as we have to deal with water rights now and in the future. The Menominee Tribe versus the United States, 1968, held that tribal treaty rights are preserved unless Congress clearly expresses otherwise. The Supreme Court decision, the majority opinion, was written by Justice William Brennan. It held that federal statutes ratifying the 1891 agreement reserved hunting and fishing rights for the Colville Confederated Tribes, making those rights the supreme law of the land under the Supremacy Clause, Article 6 of the Constitution. This meant that Washington state game laws could not be applied to the Indians. There was a dissent in that opinion by Justice Rehnquist and Stewart, who concluded that Congress never clearly enacted Article 6 of the 1981 agreement, so there was no Supremacy Clause preemption. That means that federal law does not override or preempt state laws. They express that Washington's game laws applied and the convictions should have been affirmed. Finally, later cases citing Antoine v. Washington v. Washington State Commercial Passenger Fishing Vessel Association from 1979. This case on tribal fishing rights in Washington cited Antoine to reinforce that treaties and agreements protecting tribal rights have the force of law and limit state power. The principle of this case, or the key principle of this case, reaffirmed and expanded tribal treaty fishing rights under the supremacy, showing that treaties must be interpreted liberally in favor of tribes and are binding on states. U.S. v. Turtle, 2019, the court ruled that the Seminole tribes' usufructuary rights do include the right to sell alligator eggs, but also held that the federal government can enforce reasonable and necessary conservation regulation, in this case, protection of the American alligator. A usufructuary right, I like that word. A usufructuary right is the legal right to use and benefit from another's property, especially natural resources, without holding title to it. Finally, last case, United States v. Zepeda, is a leading case in federal Indian law. It clarifies that for the Major Crimes Act to apply, the prosecution must prove both Indian and tribal recognition. It also confirms that crimes by Indians in Indian country fall under exclusive federal jurisdiction. But usually the way that law is read is by tribal enrollment, or that the tribes get to determine who their members are. Now, there was a dissent in Zepeda asking whether Indian status is a racial classification tied to ancestry and blood, or political classification in which the tribe's citizenship determine their members. And that's the end. I'll see you guys soon. Thank you.